into your litigation account. So I want to acknowledge all of the help, and without all of that help, we couldn't have gotten to where we did. And again, I want to say we're not where we need to be yet, and there's still a lot of work. So I'm going to talk about the McIver case, just give you a little bit of a scenario about what happened. Some of you will know that for many years the Indian Act had built into it a mechanism that determined who was recognized as an Indian or not. And very early on, the early Indian legislation, pre-Confederation legislation, basically recognized an Indian as a man, his wife, and his children. And so in order to get recognition, you had to attach yourself to a man. If you're a female, you had to attach yourself to a man. If you didn't, then you wouldn't get recognition. And that, in its various forms, continued into Confederation and right up until 1985. April 17th, 1985, the Charter of Rights and Freedoms, Section 15, kicked in. And it said that you cannot discriminate based on gender, among other things. And so in April 17th, 1985, it kicked in. The legislation had to take those sections out. The bad section was the one called 12(1)B of the pre-85 Act. And it said that if you were an Indian woman and you married an Indian man, or the effect was, if you married an Indian man, you lost your right to registration in its various forms back to pre-Confederation. And so it had a devastating effect on women. I told you a little bit about Sandra Lovelace, but there are other women that didn't know it was going to happen, and it was an automatic thing that happened, and they lost their right to their families. There are cases that I run across in doing other research, where a case up in the northeast or the northwest coast, where an Indian man, the case was about an Indian man that lost his fishing equipment, like his nets and that, and he was also charged and convicted and fined with distributing his food fish, because at that point in time Indians were allowed to fish but only for food, and it would salmon and only for food, and he distributed his food fish to someone who was not entitled. And the case showed that who he had distributed his fish to was his daughter, and his daughter had married a non-Indian man and therefore lost her recognition as a status Indian, or lost her recognition to be an Indian, and she was no longer entitled to get the fish that he'd been giving to her for years and years and years. So there are a lot of devastating effects. It meant that you could not live on reserve. It meant that you could, and at times could not go on reserve, so that you were isolated from your family. So you would have to, even if your marriage broke down, you could not go back on the reserve and live. And so in 1985, after years of protest by the Aboriginal, the Aboriginal women, some Aboriginal women in the community, those Aboriginal women that were subject to losing the status or the recognition, and then support groups, other national and international groups that recognized the wrong here. The law was changed, and it was a great day for those who had lost. And Minister David Crombie, who was the Minister of Indian Affairs at the time, personally went over and gave Mary Tuax Early her status back, the very first Indian woman to get her status back after the changes. Ironically, the law was supposed to take effect April 17th, 1985. They actually didn't finish it until June of 1985, and they backdated it. So, what happened in 1985, I was just finishing up my law school. I finished my third year of law school in December of 1985. So in September of 1985, I sent in an application to have my status and those of my children. A year later, I got a letter from the department to say that they recognized my status, but they did not recognize status for my children. And so I sent a letter back protesting it, and I got a letter from the department in February of 1989 to confirm that yes, I could have status, but my children were not entitled to. And so in July of 1989, I filed an appeal to the then BC court, county court, which was the legislation that the Indian Act dictated that that was my next line of appeal. And over the next, well, 89, 99, 2006, yeah, 2006 is when I went, we got into the courtroom. So about 17 years later, but over the next 17 years, did a lot of work to try to get into the courtroom. And it was an interesting time because the Department of Justice, the representatives for the federal government, for all of the Indian cases had a strategy of the Indian status cases, the recognition cases, had a strategy to say, first and foremost, that they consulted with the Aboriginal organizations pre-1985, and the Aboriginal organizations agreed to the new legislation, which in fact continued to discriminate against the descendants of the women who had married out, basically. And of course my response to that was, well, nobody has the right to agree that I can continue to be discriminated against. And it's not a valid argument. But anyway, they also said that they had 20,000 documents that they had to review because of the consultations and all of the research and that they did before changing the law. And so each time that we had a court date looming, the Department of Justice would go in and say to the judge, well, you know, we have this and we have this and we have these 20,000 documents and we're not going to be ready for X number of months or until next year. And the court would give them an adjournment. And what they were doing with the other cases, because there was more than my case out there, they were telling them, well, going for an adjournment and saying, okay, you wait for the McIver case, because that's the one that, you know, that once the McIver case is decided, and then we'll know what we're going to do with all of the rest of the cases. And so what they were doing with the McIver, which was the leading case at the time, and I think it's probably because I got in the door first, was that they just kept postponing it. And so this is where our good friend Rob Grant got involved, and we were talking in the 2002, 2003 now, and he practices this kind of law in the Supreme Court of BC, which happened because they abolished the county court during that period of time, and the case went into the Supreme Court of BC. So Rob knew a few rules that might assist us, and one is called Rule 18A. And it's basically an abbreviated route to get into the court. And so what happens is that you can apply to the court to have what they call an 18A hearing, which means that all you do is you file all of your evidence by affidavit, and then you don't have live witnesses that come into the courtroom. You just file it, and then the lawyers come in and argue it based on the affidavits, and then the court will make a decision. So Rob suggested two things. One is that we file an 18A application, and two, that we ask for a case management judge. Because every time the justice came forward, they just happened to get a judge who was sitting that day, and they had no clue about what was going on with the case or anything, and they didn't want to have a clue because it actually meant that they had to read all of the documents and that, and it was just for emotion. And so the Department of Justice had a very easy time getting an adjournment. So we made the 18A application, and Rob also made the application for the case management judge, or the lawyers did, but Rob was the one that was the expert in this area. And so what happened is we didn't get a decision on the 18A application because there had to be more evidence and more argument on it. But we got our case management judge, Madam Justice Ross, got our case management judge. And so it meant from that point